Okay, I think we'll get started. Thank you so much to everyone who's already shared with us today. It really kind of, especially hearing voices from these territories, to me, I really think about preparing the floor, like laying the groundwork for everything that we do in this place here today. And so, just to really appreciate all of you for witnessing, for listening and engaging. And that is also a part of upholding the work of our laws and governance. So appreciate each of you. So now we have a wonderful panel of speakers. I'll briefly introduce each of them, and then they'll have each group will have about 20 minutes. We won't have questions, but as Heidi said, we'll have an hour over lunch where you're welcome to chat with the speakers and have conversation. So first we have three speakers from Kiiwetinepinesiik, and I'll introduce them briefly now. So Maiyaz Julian here is a proud member of Kiiwetinepinesiik, belonging to the Lisuyu Frog Clan and to Nation River and Carp Lake Keos. Her legal consciousness and community-based practice are informed by these kinship and territorial relationships. Currently completing her undergraduate degree at UBC, Maiyaz recently completed a research practicum with the Kiiwetinepinesiik or Natural Resource Department, where she focused on revitalization of Dakelh legal orders through story work, a methodology grounded in Dakelh ways of knowing and oral traditions that she'll be sharing with you today. And Heidi and I have had the great pleasure of also working with Maiyaz on Healing Bodies, Healing Lands project that we've been working with the community on, and have some wonderful community members here with us today. Charlotte Rose is a member also of Kiiwetinepinesiik with paternal connection to Samayath. I might be mispronouncing that, with a Stalo. She belongs to the Kiiwetinepinesiik. Hopefully you'll introduce yourselves as well again, and maintains deep familial and territorial relationships across both Dakelh and Stalo nations that continue to shape her legal consciousness, responsibilities, and scholarly orientations. And Charlotte is a practicing lawyer whose work focuses on the revitalization and application of Indigenous legal orders, particularly those grounded in ancestral or KO governance systems. Presenting with them is Seraphine Munroe, Director of Land and Stewardship, Natural Resources Department, and working to bring Dakelh legal orders into that department with Kiiwetinepinesiik. And so we'll hear a bit about the collective and intergenerational work that they're doing to revitalize their legal orders today. Emma Feltz is an assistant professor of socio-legal studies in the Center for Criminology and Socio-Legal Studies at the University of Toronto. A settler scholar, writer, and anti-colonial activist, she draws on more than a decade working in alliance with Secwepemc and Tsilhqot'in peoples in the interior of British Columbia. And her new research looks at state and Indigenous jurisdiction through the climate crisis, focusing on Tsilhqot'in fire law and stewardship. And then finally on the panel we have Dayna Nadine Scott, who's a professor at Osgoode Hall Law School and the Faculty of Environmental and Urban Change at York University. She was appointed as York Research Chair in Environmental Law and Justice in the Green Economy in 2018, and is the current director of Osgoode's Environmental Justice and Sustainability Clinic. And Dayna is also, as we think we heard yesterday, co-director of, with Heidi Stark, of the Infrastructure Beyond Extractivism SSHRC Partnership Grant, which brings us all here today and yesterday. So I'm sure you will hear more about their work, and you can read their full bios, but for now I will pass it over to our first group of presenters.
Great. Thank you, Dr. Sarah Hunt, and I just want to say thank you to the Lekwungen-speaking people for allowing us and welcoming us to the territory. I thought that the earlier presentation was perfect staging for this discussion that we've been having today, and so it was had a lot of gratitude for the type of work that's been going on across the province, as well as the work that UVic is doing in partnership with them, as it allows and starts to blaze the path forward in BC and provincial policy to make space for the work that we want to now do. I had kind of got thrown into the mix here to introduce and ground this work with my colleagues and family, with Charlotte and Maiyaz, and really wanted to speak to the context that we find ourselves in BC right now as it relates to advancing DRIPA and what it really means to change laws, policies, and practice across the land base to not only just align with Indigenous laws, but align to local community decision-making outside of just Indigenous communities themselves, but how we have so much to learn in a co-learning space to be able to do that. And our hope is this work here, as we've cultivated this space across our negotiations, that we are now able to fill that with the work of revitalizing our cultures, values, and principles. And we really just wanted to speak from a personal level of what that really meant to us in doing so. So the title of our slide is our Dakelh legal orders looking through a lens of Athko, or relationality. Oh, give me a second here. That jumped like 2 slides. So as Dr. Seraphine mentioned, my name is Seraphine Munroe. I'm the director of Yunkahawanline, which is our stewardship department of Nek'Azli. Nek'Azli is a part of the Dakelh Nation, which is a Dene-speaking peoples or Athabaskan-speaking peoples in the central part of British Columbia. I also come from the Samath First Nations, or Stalo First Nations, and I was, like many of us, as Shannon had mentioned, we were raised at the negotiating table. I have a background in archaeology and forestry, and I'm a registered professional archaeologist, as well as a current advisor and technician to many of the collaborative stewardship tables in BC. So again, who are the Dakelh people? We're in central parts of BC, and the arrow that you see there in the middle is pointing at Stewart Lake, or Nakelh. We are governed by systems of clan and KO. And it's an area so similar to the Wilp or of Wet'suwet'en and Gitxsan people or Yinta. It's an area of responsibility that is held by a family and is a hereditary system of leadership. The laws are built that are long-standing relationships to the land, and we really want to speak to that today because while we have all of our KO systems about how decisions get made, and while much of our community and through the nation-based exercises in working with BC, we've been able to prove not just infringement over our territories of large-scale impacts, but the change management that needs to occur in order for us to have greater decision-making authority over the land base and what that looks like. I'll speak a little bit to that. I think that I like to, again, contextualize what we're talking about here, in which when we talk about relationships and our communities and how many of these things are interwoven into our protocols and practices as Indigenous people and how we relate to one another and therefore relate to land. The displacement of Indigenous people meant the displacement of those systems, and the emplacement of colonial laws that really looked at unfettered access to the land, that was exclusionary and extractive and supported exportation. So all of the laws in BC that affect us in our region, our neck of the world, is really focused on that. That picture there is just a big rock that a logger had placed, and they drilled a hole into it. So I thought it was very symbolic, and it looked over at Stewart Lake there. So I went there, and we saw it when we were hunting with my grandpa, and I was just like, well, there's just a lot of these cultural markers across the landscape within our territory that really kind of shows symbolically what violence on the land base really looks like, and how it aims to take power away from our people. So, looking across, there's to the right, there's a bunch of our pictographs that we're going to be showing here. So when I talk about, again, what does violence on the land look like and why does it substantiate the need for cultural revitalization of our, not just decision-making authority about who gets to decide how the land is to be managed, but what really goes into a decision of its management. And this is supposed to be a video of just showing since I was born in 1990, of just the rapid deforestation of our territories, in which we have, I believe the majority of our territories south of the Nation Lakes are now looking about 20% worse than what was defined in the Blueberry River Yehi case, if people are familiar with that one, as to where they had proven cumulative effects, in which, and they're nodding their head and talking about what, oh, there it is. Is it working?
No, it just shows the next.
Oh, there you go.
There you go.
Yeah. Oh, that's okay. Well, it's a video, but it's I really wanted to showcase like the impacts as to the territory, as to how much has significantly changed, and the red lines across the territory are all now roadways. We have almost a million square kilometers of roadways that crisscross our territory, and right now those roadways are filled with hunters, and we're one of the last places in BC that have open season on 2 spike bulls. So, everyone and their mom is out there right now crisscrossing the territories of whatever's left for hunting of moose. So I practically live out on my KO, and many of us still rely upon it, and majority of our cultural lifeways, and because of the impacts of colonialism and poverty, we have to, our 80% of our diet has traditionally relied upon fish and moose, but those are being, we don't have it in the same abundance whatsoever. In my KO all summer, I have not seen one single moose, but yet I see 4 hunters a day now. So there's a lot of impact occurring. So and many of those hunters in the territory also, I think the challenge in BC right now is when you look at the political right and the political left and where Indigenous people stand, oftentimes what people are fighting for is usually they're aligned with Indigenous value sets of local decision making and focusing on the well-being of community and having healthy land, and that supports all of these things, but it's more just driven on the value system of entitlement as opposed to reciprocity about how we live in relation to one another and have to take care of it. And then also usually follows, and as we see in academia, as to the argument about how it gets taken care of and who's right about it. And then while we're fighting about those things, the land disappears. So the impacts of disconnection within our community, again, we were talking about outcomes as to it has disrupted family dynamics. So across our KO, with the deforestation and the lack of resources, many families are in competition with one another. So people have to spread themselves across the territory in order to access the same level of resources that we used to, and just be able to rely only on one central area with our family territories. So there's a lot of competition that's fostered between that, as well as the overlaps between communities themselves. This has exacerbated social conditions within our communities. I believe the median income within Dakelh of women is something around $14,000 a year, right, of just living on social welfare programming and those kinds of things. And there's been heavy impacts of relationships to the communities, and accelerated losses of language as a result, because the language itself is place-based. So the word KO in our language means, K is in shortened form, has roots in the word Keskwat. And I will let Charlotte and Maiyaz speak more to that as well. So Keskwat is your feet. It is what grounds you to your earth, and then Yoch is your house. So it's the land that we walk on that holds you, is essentially how it translates. So I had heard other presenters earlier that really talked about how seeing it through the lens of your language is so important in our processes of revitalization and our values and how we see one another and our responsibilities to one another. So my role as a director in our community has really been about how do we create space for Indigenous knowledge and cultural revitalization. And, I look at someone like the work that Shanna has done within our community and how that work started 20 years ago. And now we're just kind of coming into that ourselves. Like we're 20 years later and we don't necessarily have the same basis of land or our elders. However, we are the last generation at this point who, we're the last generation that have walked our trails before they were logged. We're the last generation who have heard our elders speak and tell our stories on our land in their own language. So and we're working towards like revitalization of those systems. And yet there's so many things like within our community itself. So while we've had all these losses, we have all this beauty in our relationships and our customs and the inherent ways of being and how we treat one another with respect. So it's one thing to say that we have respect, but then it's another thing about how does that really articulated and defined across different modalities and contexts of how we interact with one another. So I am going to have a different form of respect within community when we're talking about fish governance and smokehouse than I would when I'm going across to someone else's KO and asking for permission, for instance, of if I can go and hunt there. My custom of respect in those ways are really going to be tied to kinship. And I was talking with Sarah about this the other day as to like, I would never come down here to Sarah's territory and be like, hey, Sarah, I'm here, can I go hunting in your territory now? Like, no, that's just it's a disrespectful question to even ask someone. When you are not tied in, like you're not interwoven into her community. I am not accountable to her family or her land. So I wouldn't even dare to even ask those things unless I have some sort of custom where I would be tied and accountable to redistribution of goods and wealth and reciprocity back to the land. So that's what we mean by like our protocols and customs of respect and how they're contextually based. So my role in the work that I do now as director of Yinkahuanline is looking at shifting our laws and landscapes and leveraging, what exactly the losses are being endured by the community itself, and then how we work across spaces with BC. And then developing co-management agreements so that it leaves us enough space between like what we negotiate back, because our community is in the process of where we now have become the largest stakeholder of forest licenses. And forestry as a form of tenure or property is a form also of power, right? In the way, like in a Western colonial sense about how we understand how power is maintained, and property rights is one of them. And so that's where our community has taken those initiatives over the last 10 or 15 years to try to gain power back. However, we're still stuck to following Western laws of forest management systems. And I think these gals are probably going to speak a little bit to that in forest fire recovery, so I'm kind of excited to hear about that. So setting you guys up. You better talk about it. Just kidding. So yeah. Anyways, like that. My role is just is creating a lot of that space with government and within our nations and getting alignment with our leadership. So to Shannon's point, we've made a drastic culture shift across BC where many Indigenous people have really had to put ourselves on the forefront of these discussions and had to convert our way of speaking in a way that they understand. In a colonial terms of like talking about constitutions and Section 35 and this is mine, right? But like while we're translating our values through a colonial lens to prove to the courts that we have a space and a belonging here, it's also translating the way that we see ourselves and the way that we dialogue internally. And so having grown up at the negotiating table and seeing that violence that has ensued internally within our communities, where our own people have absorbed that mentality as to saying, like, be exclusionary language as to, no, this KO is mine and that's not yours. But but not embodying our values about what it really means to be Dakelh, what it really means to take care of each other. And I think some of that had kind of got lost through the processes of what we've seen of the Indian Act and reestablishing ourselves. And now that we have gotten this power as a result of us taking those necessary steps to fight and speak in terms that they can understand, we now have to turn inwards. And this is where I really believe that like our next generations are going to be doing that work. So similar to what Shanna was saying around like, oh, like I'm 20 years old, but then when I'm working with Maiyaz, who's actually 20 years old, I'm like, I'm not 20 years old. 24. But I've been working at this the last 10 years, and my colleague Tina has been working, she's our elder and my advisor and mentor here, who's here today, has been working at this for the last 40 years, right? And so really building successionary planning, and amongst us as women within our community as well, who have a greater form of responsibility and care to our families, right? Like we are not just doing this work as our jobs and get to leave it at the door. We also carry our families on our back and taking care of our kids and what it really means for our children to come into this where they aren't necessarily having to fight. Like we're done with the fight internally with one another about who gets to be here, because now the idea is to create wealth and abundance. So we're not, fighting over the pennies that government throws at us in the middle, right? So that's a little bit about the work that had brought us here. And that's just another diagram is talking about the relationships as to, I'm really not good at this, sorry guys.
Give it to me.
Yeah. Just like an elder. Sorry about that. But maybe we'll use that slide and just recognizing that we need a bit more time to go through this. So I'm just going to pass it on over to Charlotte and Maiyaz to introduce themselves and the work that they're doing. So thank you so much.
Merci, Seraphine.
Okay, it wasn't Seraphine's fault, is what I'm saying.
No, all good.
Don't give it to me.
Yeah.
You're 20. Everything's touchscreen right now. I had to deal with that before. Yeah. Where's the touchscreen? Hi everyone, I'm Maiyaz Julian. I was born into the Lasiliu clan, which is our frog clan up at home, and our responsibility is to be the protectors of the water. My parents are Anne-Marie Sam and Sean Julian, and my maternal grandparents are Fred and Florence Sam and the late Ernie Sam, and my paternal grandparents are Art Julian and the late Rita McKinnon. And I just think to center myself in this conversation and taking off what Seraphine has said, I almost called you Charlotte, I'm so sorry, is just like the impacts that the Indian Act and colonialism had on us and how it was explained to me by my mother, and the divides that were placed on our communities is that my great-grandfather, Frank Martin, and I'm going to read from this because there's a few things, was born in Yekuche, baptized in Dakelh, received a hereditary name from Lake Babine, was a registered member of Glasden First Nation, and married into Nakasley. So there I have 5 connections to different communities surrounding us. I'm not just Nakasley, I am Dakelh, and that means something. I'm going to pass.
Oh, yeah. Merci to my family. So as Sarah had introduced, so I'm both Dakelh and Stalo on my mother's side, matrilineal line. Very proud and honored to be the granddaughter of the late Sally Sam, who was the Kiiwetinepinesiik or hereditary chief of our KO, Mayu KO. As well, on my father's side, come from Samath or Sumas First Nation, tied to the Kelly and Silver family. And of course, as Seraphine had noted, as well as through relating to Maiyaz's journey, it definitely came as a result of our inherent ability and strength of our ancestors to do this work, and that responsibility and obligation to fight for our land and fight for our people and who we are. And as Seraphine had noted, there's a complex context that's at play when as Indigenous people, and a big driver of where we come from, as well as our future, is to be able to give back to our community. So with that, I've had the privilege and honor to be able to seek a legal education and become a lawyer. But of course, with Western education, and really thinking about that ancestral strength of where I come from, that continuum of that advocacy is where I draw on my drive for becoming a lawyer, and through the lens of that ancestral strength itself. And I'm a mother of 2 beautiful daughters. And of course, with this work, I've had the opportunity to work across many tables, including government-to-government tables within the interior of BC, and have had the opportunity to work with amazing individuals, including Ilru, and be able to really have an abundance of knowledge and be able to give back to communities within the work that I do. And through that experience, I've been able to come full circle to my own community and do this work in a really meaningful way, which Maiyaz and I will go through in terms of that intergenerational knowledge transfer that's happening in and amongst the work that we do, which is super, as Seraphine had noted, is that the systems that have displaced or dismantled our relationships out on the land through policies, Western policies, laws, legislation, etc., have really impacted our relations to one another. But of course, with this work, it's just a profound experience to be able to do the application, move through the revitalization or restoration of legal orders, but do that in a way that really also is restoring our relationships to one another in that care and ethics through a Dakelh way. Go ahead, girlfriend.
So Seraphine touched on this a little bit, that we are the Dakelh people, so that roughly translates to the people who travel by water. So I've always just been taught that the water was the highway of my ancestors. In fact, when I would say forced, my mom would say gently urged to canoe the entire length of our lake, which is about 70 kilometers, and I would be complaining, and she would be like, our ancestor would do this in a day, you're fine, and then I'd have to keep paddling. But what I wanted to share with you guys is where our name came from. So our name is Nakasliwatan, but it comes from actually a phrase that is told in a story. So one of our oral histories tells us how we got this name. So the full phrase is Atna Nayaz Ka Ba Tizli, and it shortens to Nakasli. So I highlighted the red letter so you could see where it came into, and that means the place where the little people's arrows floated off. So long ago, there were little people that lived in the rock cliffs along our lake, and they were often at war with our people. We did not get along, and that is made very clear in the story. But during one of these times of war, the little people shot so many arrows that a causeway that used to block the south end of the lake broke off, and it floated down the river and formed a new island, and then the place became known as the place where the little people's arrows floated off. Let's see if I can get this to work. No.
You can do it.
I pressed it once. It went back 4.
Is this mine?
Yes.
Okay. So yeah, I'm just appreciating the lovely introduction from Seraphine in terms of that contextuality that's super important for this work, and of course echoing from the last presentation in terms of the power of restoring Indigenous legal orders. So for us, Dakelh legal orders, so the project itself is of course a massive project, as the previous presenters had mentioned, in terms of the scope and length itself. But overall, in terms of the restoration of our systems, to be able to move and create space for Dakelh legal orders to be able to be, am I losing? Oh, there we go, okay. To be able to be implemented and applied on the land itself, so that we can see relation in living on the land itself. So when it comes to our work together, I'll let Maiyaz speak to how it came to be.
I'm not touching it anymore.
Yeah, I got it, girl.
Yeah. So I came into this project through a UBC practicum. So last year I was coming into this research practicum with the First Nations and Indigenous Studies faculty, and it's where you're normally placed with a First Nations organization in Vancouver. That didn't work for me. I wanted to do my own thing and work with Nakasley, and thankfully I had support from my community, from Seraphine and Rosemary Sam, and from my practicum coordinator. So they let me kind of, like I said, do my own thing and do something that benefited my community directly. So through this and through I think it was 9 months of conversations with both sides, we finally landed on the Dakelh Legal Orders Project, which was a story work approach to revitalization. And I got paired with Charlotte Rose, and I didn't know her before, so I say introduced, but we've always known each other. We are family, but I didn't know her in this capacity, and she took me on and we just had our little relationship, and she's my mentor, and she's taught me a lot, and that is, how do I do this work ethically? How do I do this work in my heart in a good way? And so we had 8 months in this practicum project, and it kind of culminated into a final research presentation, much like this one. But I kept going. I was originally meant to leave my hometown in April, but that did not happen, and I am still living there again, which is not a bad thing. But if we just want to go.
Yeah, and I'll just jump in there. So I'm really proud of like how this work has just created that building of care and relationship between the team that we work with at Nakasley. Having Indigenous-led processes absolutely help all around, but really allowing for that knowledge transfer to be able to have an opportunity to transmit is super key to this work. And really through her learning and capacity building, she has a deep sense of purpose, and especially being in community and being able to maintain those relationships.
And then this is the last slide, I promise, after this. So I'm going to stand up for this one, and I will take the scary remote. But so the story that we ended up choosing was Dachan, the Legend of the Trees, and I'm standing just so I can kind of point to things for you. So in this story, we were once again told how we should steward our lands. What are the responsibilities that we hold to the trees specifically in this instance? And so how the story goes is that long ago, trees used to be free-moving beings. They listened, and they learned how to talk with the humans. They understood us. And at one point, a man entered the forest. And the man made the decision, needed to harvest wood, so he approached a tree that was half dead, half green. At the time, the law was that you had to take already dead trees because the trees had a right to live. And so he just started a fire to burn down a tree, and the balsam tree stepped in and said, don't, and reiterated the law. Poplar stepped in and said, no, we're overpopulated. He's dead, take him it's fine. And they had a physical altercation that resulted in the balsam tree falling directly into the fire started by the man and getting burnt and blistered. The poplar fell alongside the fire, and it got ashes all over it. And then we have two other trees that came in, which is cottonwood and fir. And the cottonwood had, sorry, this kind of part does make me laugh. The cottonwood had a knife, and the fir tree had an axe. And they kind of just were name calling each other and said, do you agree? And started fighting as well. So this one, the cottonwood knifed, a direct quote from the thing is, knifed up the fir tree, and the cottonwood and the fir axed up the cottonwood, and that's why their barks are the way they are. Firs is shallow, cottonwood is deep. And then we get to the last set of trees, which is the jack pine and spruce, where again, they're just name calling, saying that they're better than the other, that they have better shelter for the birds, and they decide to start whipping each other with their needles. And that's why their barks are rough and scaly. So that is the story that we looked at, and the principles that we were able to pull out ended up being principles of respect, responsibility, unity, a right to protection. And there's one I'm missing, so I'm gonna look. And reciprocity, so sharing knowledge amongst the trees. And from this, we were able to think about what should have happened. And we were able to develop just protocols of how you should actually behave with one another, because this reflects our interactions as people as well.
Absolutely, and just lastly, understanding those principles that we extracted from those stories, that richness and also the process in which we engaged in together is really, has been really profound in terms of the development of our relationship, which again is an example of the power of this work, especially on a community basis, to remind people that these laws are living, they are here, and they will be able to guide us moving forward.
You can close it.
So grateful to be here on these lands among like heroes. And thanks for the setup. I'm going to talk about fire. The theme of this symposium sparked for me really a new lens through which to think about work that I've been doing with two Tsilhqot'in communities. It has made me start to think about jurisdiction as care work. It's also made me think about the ethic which undergirds provincial expressions of jurisdiction as being something other than an ethic of care. And so I wanted to start with a brief story about fire and provincial jurisdiction that relates to the previous amazing presentation. So 150 years ago in 1874, BC was the first province to outright ban Indigenous burning practices. Until that point, some form of what you might call controlled landscape burning was practiced by Indigenous peoples throughout virtually all of BC, and different nations have articulated different reasons and priorities for why they burned. And of course, this will be familiar to others from communities who have long histories of working with fire. But Sarah Hunt, all of a sudden I feel super awkward citing you in front of you. Sarah Hunt has recently written about how the routine burning and clearing of land by Coast Salish women, and she's quoting Cheryl Bryce here, was an expression of ownership and transmission of socio-legal knowledge. And for the Tsilhqot'in, who I work with, it was also used to promote biodiversity, because when you burn away dead grass and other organic matter, it brings back berries and medicines and root vegetables, and in turn, animal relations and wildlife. And it also has the benefit of preventing, or at least mitigating, out-of-control wildfires by burning off dry grasses and dead leaves and other, what the province calls fire fuel, left on the ground. So when the province banned Indigenous burning in 1874, this was 2 years before the Indian Act, of course, and this ban on burning was a kind of harbinger of assimilation policies to come. Again, as Sarah writes, such bans were an assertion of colonial control over both lands and First Nations, whose fire practices were portrayed as a risk to settler futurity. So the ethic behind it was surely an assimilatory one, an ethic of jurisdictional dispossession, of clearing the lands in another way, of clearing them of Indigenous territoriality. And when the province then introduced the first Forest Act in 1912, it doubled down on this policy of total fire suppression. And the other rationale that they gave in 1912, and we found this in an article in the Daily Colonist, was to protect what it called forest wealth, so logging revenue. Fire suppression, as it was rationalized and legislated in the early 20th century, was about logs and jobs, right? Protecting the trees so that they could be logged, protecting jobs in the logging sector, and protecting the tax revenue that the province would receive from this resource extractive industry. So the ethic here, in addition to being one of jurisdictional dispossession, is one of commerce and extraction and revenue. And then this policy of total suppression would span the entire 20th century. So transforming the landscape, criminalizing First Nations fire stewardship, fueling the mountain pine beetle epidemics that would come, and leaving piles and piles of fuel in the form of dead trees and debris on the ground, rife for the kinds of apocalyptic wildfires that climate change now ignites in BC every summer. I said this before when I presented on this, but rarely can something so directly be tied back to one particular colonial policy as the wildfire we now see in BC. So fast forward to the 2020s, and the province has sort of realized the error of its ways, realized it created this tinderbox, and that there really is something to this practice of burning as a method of wildfire prevention. And in October of 2023, just about 2 years ago, BC announced plans to amend the Forest Act and the Wildfire Act to formally embrace what it calls prescribed burning, and give it legal standing in BC's, quote, forest management toolkit. But the press release where they announced this reads not unlike that Daily Colonist article from 1912. The rationale is laid out to, quote, conserve fiber supply and preserve good jobs in the logging sector. So again, it's about logs and jobs. Now the policy has changed, reversed from suppression to prescription, but kind of perversely, the ethic remains the same, commerce, extraction, and revenue. And I'd also argue that the ethic of assimilation and jurisdictional dispossession also remains, despite the fact that now the province's interests now align with Indigenous knowledge of fire mitigation. It's called, prescribed burning is described as a new tool to manage crown timber harvesting, with the added benefit that it can address, quote, First Nations interests in how forests are managed. But it's really about squeezing what it calls cultural burning into the provincial model. And they have to go through this bureaucratic process where you submit burn plans and there's 5 signatures and you often miss the window to burn, et cetera, et cetera. So the ethic of assimilation and jurisdictional dispossession persists too. So let me back up a bit. As Sarah mentioned, I'm a white settler scholar. I've worked in solidarity with Secwepemc and Tsilhqot'in peoples in interior BC for the last 15 years on projects that have mostly been about reestablishing Indigenous jurisdiction in the context of international and constitutional law. I never anticipated that I would be working with fire, but in 2017, a set of wildfires swept through Tsilhqot'in territory, which were at the time the most severe wildfire in BC's, recorded in BC's history. New precedents have been set since. And I was brought on as part of a team to produce a policy report about the jurisdictional conflicts, really the, again, attempted jurisdictional dispossession that arose out of that devastating wildfire. And so together with a collaborator of mine, Dr. Jocelyn Stacey from UBC Allard School of Law, and Estee Law community member Crystal Varai, we wrote a report called The Fires Awakened Us and started supporting the Tsilhqot'in national government in its moves to assert jurisdiction in times of emergency. Now, a year after those wildfires, 2 communities, Unesitine and Hanigwitine, began a fire stewardship program led by former Unesitine chief Russ Myers-Ross in partnership with a nonprofit called Gathering Voices Society, where they started burning the land, revived the practice of fire stewardship on the land. They started burning on reserve and quickly expanded to burning on Tsilhqot'in title lands. As many of you know, the Tsilhqot'in have a declared title area from their precedent-setting 2014 Supreme Court declaration. But they want to be burning all of Tsilhqot'in Nen. In that decision, the Tsilhqot'in decision, the court ended up kind of distinguishing and dividing the claimed territory between title lands and what are called rights areas, and the communities want to be burning everywhere, title lands, rights lands, crown lands, all of their Nen. And so a couple of years ago, Russ came to Jocelyn and I and asked whether we could make the case, the argument that they have a right to burn, meaning like a constitutionally protected classic Section 35 Aboriginal right to burn the land. But the question was not just, do we have a constitutional right to the practice or the isolated cultural activity of burning, as you know the Vanderpeet test would want it to look like, but more, do we have a jurisdictional right? Do we have a constitutional right to steward fire and to manage burning in a way that is consistent with Tsilhqot'in law? So we set about learning about this question, and methodologically we started by going out and burning with the communities during the last few burning seasons, and we're building towards starting interviews with community members including elders and knowledge holders this spring. But before we start those interviews, we decided to do a kind of inventory of all of the knowledge that has already been documented and recorded that pertains to Tsilhqot'in practices and laws around fire. So we started with the trial transcripts from the Tsilhqot'in case, expecting not to find much actually that pertains to fire. And we gave an amazing law student, and thank you to Hoku for reminding me to name this law student who went through 22,000 pages of trial transcripts for us this summer, Morgan Green. And she found testimony from community members like Norman Seta, Baptiste Ritchie, and Minnie Charlie Boy. And so I wanted to highlight this one statement by Minnie Charlie Boy, where she said, when there's a burn, it usually turns the land to have a lot, more berries and stuff. Turns out better. If there's a lake and there's little islands, what they used to do is burn those little islands so there will be some raspberries growing in those areas. Anything, if you want it to regrow, you have to burn it and then it will regrow again. After a while, they didn't want you to burn any burns like that. Forestry doesn't want you to make fire. If you're gonna burn your meadow, you have to get a paper from forestry before you could burn it. And so I love this line, if you want it to regrow, you have to burn it, which is the title of the talk. And last week I was at John Burroughs Law Camp at Rama, and I was kind of talking to him about some of the methodological challenges we've been having, and he was asking me what analogies we can pull out of fire itself that contain legal principles in them. And I thought of this line, if you want something to regrow, you have to burn it. And on the one hand, it's like the perfect analogy, like, aren't there so many things that we would like to burn down for something else to regrow in their place? But it's not a metaphor, burning is not a metaphor. You have to literally burn the land to take care of it. And so this is where the ethic of care, I think, comes in. When the Tsilhqot'in burn, they're taking care of the land in terms of protecting it from wildfire and from pine beetle. They're also taking care of the berries, the root vegetables, and the medicines, which we have witnessed grow back even in the 7 years that those two communities have been burning. They're taking care of animal relations and wildlife that come to eat those berries and vegetables and to graze in healthy meadows. And then the people are taken care of. And so Russ has talked about how when he assembles these crews to do the burning each spring, he'll often have a few people who are hunters and a few people who are basket weavers. And, they'll go out on the land and each person will sort of see it in a different way. Some people will say, oh, there's berries growing here now, I'm gonna come back later this summer and do my hunting. And the basket weavers will say oh, this is where I can come and get healthy bark and needles. I'm going to grab some while we're out here. And Gathering Voices actually got money from Health Canada to document some of these impacts on social welfare through the transfer of Tsilhqot'in knowledge between generations working in the program. So really it's like care upon care upon care upon care, right? And this shows that fire then is a sort of critical piece of infrastructure, you might say, of what is ultimately a resurgence of territorial care. I was listening to everyone yesterday and thinking about the way some conception of care has often been used as a kind of moral argument for key areas where communities have gained jurisdiction back from federal and provincial governments, so namely in the area of child welfare, where the provision of care to one's own community members has been kind of mobilized to make these huge, important strides in getting jurisdiction back, as Mavis was talking about earlier, how much work that has been. And these major wins, jurisdictional wins, through that work. And the Quebec reference, which upheld Indigenous jurisdiction over child welfare, is explicit that self-government is an inherent right rather than a mirror of provincial jurisdiction. And Scott Franks points out how, in this case, the court refers to the honor of the Crown to suggest that Canada has actually bound itself to recognize Indigenous jurisdiction, at least over Indigenous people's own children and families. But this is an area that we might call sort of population-based jurisdiction over a community's own members. And so this case really focused on how a community takes care of its own children. And it seems like governments are becoming more willing to, quote unquote, hand back jurisdiction in these areas. But Eva Jewell made this beautiful point yesterday about how child welfare is so vitally important, but we all need care, that we should think of it as a kind of first step in centering care more generally. Which brings me to the other kind of jurisdiction that's not necessarily population-based, but rather land-based and territorial. So no longer confined to just one's own community members, but territorial jurisdiction applies to, or you might say cares for everyone in an area, regardless of who they are, and effectively putting settlers under Indigenous jurisdiction too. And this is, of course, the kind that the federal and provincial governments are less willing to concede, right? For obvious reasons. Territory is where resources, jobs, and revenue come from. It's definitely where the province hangs its hat in terms of the structure of Canadian federalism. But it's also much more linked to sovereignty, building on work by Shiri Pasternak and Lisa Ford. You might go so far as to say territorial authority is a kind of litmus test of settler sovereignty. And so this is why it'll be so interesting and important to see whether recent jurisprudence that advances Indigenous jurisdiction in child welfare can be applied to cases that hinge instead on issues of territorial jurisdiction, like fire stewardship. And this is the kind of experimental argument that we're preparing to make on the fire stewardship question, is whether that precedence that's starting to come out of these recent cases should be applied to, or could be applied to, questions of land stewardship too. And so in preparing for today, I began to think about how we might formulate part of that argument around care, that land stewardship and particularly fire stewardship should also be seen as a form of care that is not so unlike child welfare, that these are part and parcel. Things like land management, forestry, resource management, what if the common law could see those through an ethic of care in the same way that child welfare is understood as care for community? And the way it's also conceived in Silcotin law too, right? That care upon care upon care. And so in a previous presentation I've done for the Infrastructure Beyond Extractivism group, I asked whether jurisdiction can even fit within a right, and would we want it to? Like, what are the dangers of trying to wedge it in that way? And then today I started thinking, can care fit within a right, and would we want it to? But not talking about a right to receive care, but a right to provide care. In this case, through fire, through providing care for the land, and in turn, for plant and animal relations and for people. So could there be a jurisdictional right to provide territorial care, to burn it down, and let it regrow?
Thank you. Hi, everybody. My name's Dayna Scott. I'm really very pleased and honored to be in this room with you all, and to have been brought into this circle, and to have been sharing this space over a couple of days. I need to thank Heidi for bringing me into this circle, and I really got to know Heidi about 10 years ago at those Anishinaabe law camps at Nawash that she was speaking about yesterday. And I just really appreciate it. She talked yesterday about being a bit of a rebel in that scene. So I guess I really am drawn to that kind of human, I guess. The other thing we do together is co-direct the Infrastructure Beyond Extractivism grant. And I want to mention also that one of the first things that we had to do together in that work was basically managing a crisis. And the way that Heidi responded to that was basically to enact the very approach she spoke about yesterday, and that was, finding a way to hold each other accountable in care. And I learned a lot in that interaction. So in I just want to appreciate that, and I've just been in awe of her clarity and her energy since that time. So I'm a settler, a scholar. I have French and Scottish ancestry that goes back to the Ottawa River Valley and unceded Algonquin territory. I'm also an environmental justice activist and organizer and a mom of two completely ungovernable teenagers in Takaranto. My scholarship has been trying to understand how to overcome the unfairness in pollution burdens and the costs of extractivism that are embedded in the framework of settler environmental law. And I became focused on the energy transition a few years ago, thinking about the risk that those colonial and racist dynamics would continue on unchanged, even as we remade our economies to try to survive the climate crisis. And so I've been working for about 8 years in solidarity with and alongside the leadership of a small remote Anishinaabe community called Nishnantaga First Nation in Treaty 9 territory, the boreal peatlands of the far north of Ontario. And we're trying to understand basically how an ethic of care, really taking that on board, can shape and inform legal strategies that the community might want to take on. So we've been working together in collaboration in a spirit of mutual aid. So I'm both embedded in and accountable to long-standing and continuing relationships that are contingent, but I think always, as I said, like continuing, right? And a commitment to continuing, which builds that accountability. And there are lots of folks in this room that work alongside me in that relationship, and I'm super happy to have them here as well. This is a photo that I took in the community in 2019. It's the shore of the Attawapiskat Lake, which drains into the Attawapiskat River. The river is wide and shallow. It flows an astonishing 748 unimpeded kilometers to empty into James Bay. We have been privileged to spend time, several summers, with land defenders on that river. And this past summer, to join in a protest camp called Here We Stand, which was meant to demonstrate that people would refuse the crossing of a mining road that was meant to lead to mineral deposits called the Ring of Fire, which have been touted by Ontario's Premier Doug Ford and Prime Minister Carney as a national priority for saving Canadians from the chaos brought on by the Trump tariffs. The camp also showed a remarkable connection between Anishinaabe or Oji Cree and Cree people from communities along the length of the Attawapiskat River, which is what Michelle spoke about yesterday in terms of the muskeg and those people coming together in solidarity. And they meant to demonstrate not just their presence on the river, but their continuing relations with it. And so the Attawapiskat River, its vast watershed, and especially its lake sturgeon, constitute the life-giving, vital infrastructure that people in Nishnantaga are fighting to protect, working to maintain, and exist in caring relationship with. The minerals that the government is after are no longer even being pitched as critical to a green energy transition for electric batteries and clean transportation as they were up to about 8 months ago. But now, in the wake of President Trump's threats to annex Canada and the grip of the tariff war and its demand for patriotism in the name of economic emergency, the climate pretext has been completely dropped, and it's obvious that critical minerals are just minerals that must be mined for economic domination, for defense, and security for some. This is an image that Christy Belcourt and Isaac Murdoch of the Onamum Collective made for Nishnantaga a few years ago as they were launching a new lake sturgeon or Naame stewardship program on the Attawapiskat River. The sturgeon is a really ancient fish. Like the muskox, as Lisa said yesterday, they've been around for millions of years, have survived ice ages and major extinction events. The sturgeon in this landscape travel hundreds of kilometers in both directions along the river and can live up to 100 years. The beating heart of the lake sturgeon in the image represents the way that the Attawapiskat River is seen as the heart of Nishnantega's homelands. It's the, quote, sacred and spiritual landscape of Nishnantega, as former Chief Wayne Maiyaz says. When the sturgeon are harvested in the summer, they're dried and shared with elders in the community and their families. They're meant to nourish everyone. Leadership in Nishnantega has stated repeatedly over many years that they would lay down their lives to stop a mining road from crossing the Attawapiskat River. And that position has held firm through many changes in leadership, and even as state and industry tactics have created division amongst the 5 remote First Nations that once stood in unity against the Ring of Fire. So the reason the road is so crucial is obvious once you take a look at the map. You can see the Attawapiskat River flowing from Nishnantega over towards the bay, and there is no way to access those mineral deposits without that road. So my project has been to witness and document, in solidarity with the leadership of the community, interactions between the settler state authorities, industry, and the First Nation at the so-called critical minerals frontier. I'm focused on the encounter between the settler law and the exercise of and assertions of Indigenous jurisdiction. So one way to attend to this encounter is to become attuned to the persistent and sometimes very subtle insertions of Anishinaabe logics into dialogue or interactions with the Crown and Company officials. So these are the maneuvers by which people insert their law into colonial systems. And what I'm offering is just my observations as an outsider, of course, but again, as one that's embedded and accountable in these relationships. So what I've been seeing is that there is some friction generated in the interaction of the legal orders, and this constitutes a resetting of the colonial relations. In other words, Nishnantega's interventions and insertions of Anishinaabe logics or legal sensibilities shape and influence the settler legal order. It's not a linear progression, of course, but as Joyce Green observed in 2005, Indigenous assertions of jurisdiction and authority can and have shaped and shepherded the structures and practices of settler government in Canada from a colonial towards a post-colonial order. So it's to approach this encounter or interaction between settler and Indigenous legal orders in Treaty 9 in a way that takes the prevailing legal structure not as a given, but as a function of ongoing struggle. The future of it is not determined. Nishnantega's insertions of Anishinaabe legal sensibilities often manifest in the Register of Refusal, but they are also consistently organized around an ethics of care. So Nishnantega's leadership practice refusal in all its forms, as instinct, as tactic, as coping mechanism. They are always understanding and insisting that the right to say no is a necessary part of any viable idea of consent. And as Audra Simpson brilliantly showed us, to participate in consent-seeking exercises with the settler state, even in the act of saying no, we still reinforce the authority of the settler state to act as the arbiter of justice, to which all political activity must answer. And so communities like Nishnantega, as everyone in this room knows, dwell in that space of contradiction. And I also learned this powerfully from Rob Clifford's dissertation. So the Attawapiskat River is governed, of course, by lived obligations and responsibilities in all relations, including beyond the human, by the sturgeon, between beings, and across generations. And I just want to offer a few observations about the kind of interventions that Nishnantega makes. They are always in motion and in strategic relation. They're always oriented to drawing individuals back into a collective. They are always both inside and moving beyond the colonial structures of the present. And they're seeking jurisdiction back in the sense of always returning the question to the question of who should govern rather than who should benefit from the resources. So in the interest of time, I'm just going to discuss one of these. And that is the notion of being always in motion and in strategic relation. So by saying always in motion, I'm referencing the ability of the community's leadership to consistently adapt to new developments and to put their assertions into strategic relation with settler provocations. So movement, fluidity, and mobility obviously is also central to Anishinaabe lifeways in Treaty 9. Like the sturgeon, the community is always traveling the river according to the season. As Maiyaz says, it has always been their transportation route, their highway, their crucial infrastructure. And in the Attawapiskat, land users report that Naame hold knowledge about the health of the watershed, are highly sensitive to disturbance, are known to avoid stresses in the river system, including vibrations, sounds, toxicity, turbidity, the kinds of effects you might expect with a major industrial road. Scholarship on Anishinaabe relationships with sturgeon also emphasizes that those relationships are grounded in memory. So I just wanted to share one example from our work this summer. And the work our team has been doing alongside community members is to map the fluidity of the landscape and the seasonality of Nishnantika members' historical, present, and future uses of it. So many of you will by now have met our dynamic doctoral student Nessie Nankaval, our mapper, and she has been working and has fostered a partnership with Forensic Architecture UK to develop new methods for visualizing the possible effects of new extractive infrastructure on Nishnantika's homelands along the Attawapiskat. And through this work, we're developing new ways of describing Nishnantika's wider relationships with the river to a landscape in motion, through strategic intervention with the settler state's tactics. So as an example, in confronting the possibility of burial sites in close proximity to the proposed site of crossing for the mining road, for many people, the initial reaction was to consider conventional engagement with archaeological expertise and evidence. In settler law, heritage protection laws ideally would prevent the desecration of burial sites, leading to an assumption that Nishnantika should invest in evidence gathering, engaging an archaeologist, and substantiating what their elders had been saying. This would have led to a legal strategy of disclosure and a related demand that the proposed crossing be relocated away from the sacred site. But this would have also been a strategy that failed to capture the ways that community members and elders describe their relationships with the river, the way they understand them. They have been saying there are certain characteristics that make a good village site. For example, you need flat, high ground, dry land, close to rapids that can be used for fish weirs. There would be certain types of ecological investigations into the types of plants, for example, that are growing at various sites along the river's length. And these would offer clues as to the type of uses that had been prevalent in the past. Understanding these ecological, spatial, and geographic characteristics in combination with the elders' oral histories that describe the cultural and social life on the river, specifically the burial practices of their kin, which indicated that people would be buried very near to where they died, meaning that they could build a map of the river that placed not only the known past village sites, but not only the known past village sites, but the likely past village sites and the likely future village sites. So in other words, these places would not only be sacred because they were likely to contain the burial sites of ancestors, but because they're important sites that are useful for making camp today, and they're likely to be the sites that are important for making camp in the future. They're places important to community members, kin, and descendants. So through collective listening and rejection of the colonial logic, the community turned a remembering into a visioning exercise, a powerful prefiguration of Indigenous futurities in their homelands. In other words, Nishnantika's relations with the river, the ethic of care that they exercise, requires not that these sites are marked and avoided, but that these sites continue to be used. The settler logic of marking off a burial site at a singular place on a map and then avoiding it chafes against the Anishinaabe legal sensibility of respectful and intimate and continuing care and relation with the ancestors. That clash of legal logics also comes to a practical head with the dawning reality that the settler state and industry response to Nishtantaka's assertion of a sacred site would more than likely simply result in a new route that moved the proposed crossing site a few kilometers down the river. So the power in Nishtantaka's strategy is that it emphasizes their relations with the whole river, its integrity as a living being and a relative. They want to resist the idea of a territory marked with a hard boundary that's identifiable on a map and insist that their homelands consist of a fluid and full river across its length. So the encounter I describe here draws on the foundational thinking of Michelle Dakelh in Treaty Number 9, so I get to be in that awkward position of quoting Michelle too, through her brilliant theorization of spatial politics of Indigenous water governance and how they're, quote, regenerating Indigenous political geographies of governance and self-determination by rupturing settler colonial boundaries and logics and fixed notions of territory and nationhood. As they say often in Nishtantaka, we were here before you came looking for your battery metals, and we will be here long after. So I also appreciated the reminder yesterday that the sturgeon are trying to fulfill their own responsibilities. So in the current dynamic, which is one in which Nishtantaka feels attacked by all sides, Ontario, of course, wants to declare the Ring of Fire a special economic zone, a special sacrifice zone where they can remove the application of any provincial law that gets in the way of extraction. And Canada wants to declare the Ring of Fire as a pony, a project in the national interest. Both of these are moves specifically designed to take away tools under settler law that Indigenous communities could pick up to stop projects that they don't want. If you add to this the cynicism of those governments to believe that Indigenous loan guarantees and equity stakes are a full answer to the removal of avenues to seek genuine consent, you understand the kind of predicament that communities are in. So I think it's powerful in this context to see the agency in the insertion of these dissonant logics, however small they seem. And that's all for today. Thank you. Yeah.
So, I think I just want to express my own gratitude to all 5 of our amazing panelists who I think have really helped remind us of, not only the ways in which we can provide care and need to be thinking about care for one another, but also the importance of really caring for those other than humans that we're in relationship with, the land, the water, those beings, the animals, and also I think really reminding us of not just our responsibilities to those other than humans, but also the ways in which they are also trying to fulfill their responsibilities to us, and the importance of, trying to produce worlds in which we're all free to care for one another. So again, please join me in expressing our thanks to all of them. I'd also just like to express our thanks to Justina, the Wasanich chef who has been feeding us for 2 days. So just another round of applause for Justina and all of her hard work. And with that, we'll let you enjoy her hard work, which is available out there. Just a reminder to please let our elders eat first. For some of the students and younger folks in the room, if you could just make sure any of the elders or folks with mobility limitations that you make sure they're being fed. And we will be coming back here still at what's the time? 1:30, right? What time is it? Yep, 1:30. 1:45? 1:30. What time's lunch? Okay. 45 minutes. Yep. Okay, so we'll see you back here at 1:30. You got 45 minutes now, and we'll give you 15 minutes from now. Those who are interested in the tour will bring you together.